So my name is Anurag Bhaskar. By profession, I'm in teaching. I have my colleagues Avinash Matthews, who's a lawyer, my colleague Kundan, who is also a lawyer and recently a LAM fellow. So we have gathered here under the banner of CEDE, an initiative that Avinash, Kundan, Disha, who is not here, Rajesh, Arslan, all of them we have been doing for last few years. So under CEDE, we started thinking about it, Avinash, I and Disha, in 2020 about the need to diversify and make our legal profession and judiciary more representative. The idea was to ensure that law students and law graduates from marginalized communities, they get a chance in the profession, because we have seen structurally how the profession works. And in India, where we have so many communities who are not able to access justice, we wanted to empower those communities by ensuring that the individuals or students coming from those communities should get some entry point in this profession. So we then started CEDE. We conceptualized CEDE in 2020 and formally launched in 2021. Justice Chandrachud had launched it then. And since then, we have been doing a number of activities. So one of our primary initiatives is to help law students from marginalized communities all across the country to get them, help them in getting internships, paid internships. We ensure at least some of the internships every year. We then requested lawyers, judges, law firms to give at least one paid internship to the students which are shortlisted by us. And as of now, we have been able to, in last 4 or 5 years, we have been able to help get 450 internships, paid internships to various students coming from different parts of the country. And in our journey, we found that it's not that the students don't have potential. We have met many students through this initiative who are doing amazing, whose journey has been inspiring. Some of them came from Northeast, someone coming from remote tribal area, Maharashtra, someone coming from Kashmir. So this journey also has been inspiring for us. And apart from internships, we also help mentor students in capacity building, in applying for abroad admissions, in applying for clerkships, in applying for jobs and all of that. You can see the statistics. Apart from all of these, one key initiative that we have been doing is Dr. Ambedkar Memorial Lecture every year, where we ensure that the office holders in the judiciary or the legal profession come and talk about issues related to representation, social justice, constitutional law. The idea is to make a conversation with those in authorities, and so that it can inspire others to also engage in the work that we have been doing. So in last, I think this is our 6th Dr. Ambedkar Memorial Lecture. And previously, Justice Chandrachud, Dr. Justice S. Muralidhar, Professor Michael Clement from Harvard, Professor Ajinta Subramaniam from City University of New York, and Justice Ravindra Bhatt, last year, they have delivered our Dr. Ambedkar Memorial Lecture. And this year, we are honored to have Honorable Justice Devendra Kumar Upadhyaya as our chief guest for the Dr. Ambedkar Memorial Lecture. So we welcome you, sir. So, sir has been kind enough, and he has been helping us in our work. And whenever he also takes some interns, whenever I send him a request. And sir, as you know, is currently the Chief Justice of Delhi High Court. Before that, he was Chief Justice of Bombay High Court, and before that, he was a senior judge and a judge in Lucknow, High Court Lucknow, I'll say, not the bench in Lucknow as it is called. So, sir brings with him a long experience as a lawyer and then as a judge, and has been leading many benches dealing with landmark matters. In excise, if you see his court in Allahabad High Court, every day some of the other interesting petitions would come, and sir would gently deal with all of those petitions. So we are honored again to have you, sir, with us today. And with that, I request you to deliver this year's Dr. Ambedkar lecture.
Good evening to all. Thank you for inviting me to deliver the 6th Dr. Ambedkar Memorial Lecture organized by CEDE, the Community for Eradication of Discrimination in Education and Employment. CEDE as an initiative has been started by a group of young lawyers who seek to reform the structure and composition of Indian legal profession, taking small but effective steps. The core idea is to foreground a simple but uncomfortable truth. Our legal profession does not appear to be representative of India's social composition. Those who are in need of justice most are often absent from the very institutions that are meant to deliver it. They are not adequately represented as lawyers, as judges, or even as law professors. That absence reflects deeper barriers that continue to shape access to the profession. CEDE was conceptualized, as Anurag told all of us here, in the year 2020 and was formally launched in the year 2021. Since then, it has attempted to act as a bridge between different stakeholders, members of the bar and the bench on one hand, and the students from marginalized backgrounds on the other. Through a centralized and structured program, it has enabled access that would otherwise remain closed or uneven. In a relatively short span of time, CEDE has organized more than 400 events and sessions, including workshops and camps for law students. These initiatives are about building confidence, creating networks, and opening pathways into a profession that has historically been exclusionary. Every year, CEDE organizes Dr. Ambedkar Memorial Lecture. This is not only an occasion to celebrate the legacy of Dr. Ambedkar, it is also a moment to reflect critically on the present. It brings together members of the bar and the bench to engage with a larger question. How do we transform the legal profession so that it becomes more representative, more inclusive, and more responsive to the claims of marginalized communities? I am grateful to have been invited to deliver this lecture. I consider it my privilege to be part of a distinguished line of speakers who have contributed to this convention in past. अपना व्याख्यान प्रारंभ करने से पहले मैं एक बात डिस्क्लेमर के रूप में कहना चाहता हूं. मैं डॉक्टर अंबेडकर का अध्येता नहीं. पहले एक अधिवक्ता के रूप में, उसके उपरांत न्यायाधीश के रूप में मेरा अध्ययन सीमित रहा है, क्योंकि जो लोग लॉ प्रैक्टिस में हैं या विधि व्यवसाय में हैं, उनके लिए सीमित अध्ययन एक बाध्यता है, इट्स अ कंपल्शन, क्योंकि उनका अध्ययन किसी प्रकरण विशेष पर केंद्रित होता है, अर्थात इट इज केस सेंट्रिक. तो मेरा आग्रह है कि मेरे आज के इस व्याख्यान को इसी सीमित अर्थ में लिया जाए. डॉक्टर अंबेडकर ने एक बात कही जो मेरी दृष्टि में बेहद महत्वपूर्ण है, और वह यह कि समाज के मार्जिनलाइज्ड तबकों का पहला कर्तव्य यह है कि वे शिक्षित हों. उन्होंने नारा दिया, एजुकेट, एजिटेट, ऑर्गेनाइज. नारा माने स्लोगन. स्लोगन शब्द का प्रयोग मैं इसके शाब्दिक अर्थ में नहीं कर रहा, क्योंकि स्लोगनरिंग बहुत अच्छे अर्थ में नहीं लिया जाता. स्लोगन शब्द का प्रयोग मैं सूक्त या मंत्र के रूप में कर रहा हूं. वी कैन कॉल इट अ कॉलिंग बाय डॉक्टर अंबेडकर. तो डॉक्टर अंबेडकर ने हम सबको एक सूत्र दिया, एजुकेट, एजिटेट, ऑर्गेनाइज. The memorial lecture in honor of Dr. Ambedkar is a reminder that every year, perhaps every day, we must reflect on our progress as a society and as a nation. We must ask whether the vision that Dr. Ambedkar laid down for independent India is being realized. We must also ask how much remains to be done and what challenges continue to confront us. Dr. Ambedkar spoke extensively about rights, but he was equally insistent on remedies as well. As he reminded the Constituent Assembly, rights are nothing unless remedies are provided, whereby people can seek to obtain redress when rights are invaded. He also described Article 32 of the Constitution of India as the very heart and very soul of the Constitution. It is this emphasis on the relationship between rights and remedies that connects directly to today's theme, constitutional remedies as instruments of social change. Let me therefore begin by tracing how our constitutional framework conceives of remedies not merely as a procedural devices, but as tools through which the Constitution seeks to transform the society. It is important to recognize that what the Indian Constitution has done is quite remarkable. It does not treat remedies as an afterthought. It elevates them to the level of fundamental right. As you're all aware, Article 32, which is embodied in Part 3 of the Constitution of India, is not simply a procedural gateway. I don't have any broad idea of the constitution of other societies and countries, but this is very unique. Remedy provided under Article 32 is in itself a fundamental right. So, Part 3 of the Constitution of India has given us certain fundamental rights. To realize those fundamental rights in itself is a fundamental right. That's very unique. The students of comparative constitutional law might be knowing as to whether in any other country or any other society such a provision exists. It is itself a substantive guarantee. This design reflects a deep constitutional anxiety that the Constitution is not self-executing. It requires institutions, procedures, and above all, remedies that can translate normative commitments into lived realities. Closely linked to Article 32 is Article 226 of the Constitution of India, which vests our high courts with a wide and flexible writ jurisdiction. In many ways, Article 226 is even broader. It allows high courts to issue writs not only for the enforcement of fundamental rights, but also for any other purpose. This is the exact phrase occurring in Article 226, for any other purpose. This phrase has been interpreted extensively. It has enabled high courts to intervene in a whole range of situations where legal rights, even outside the strict domain of Part 3, are threatened. The writ jurisdiction under Article 226 and 32 includes the classic prerogative writs, habeas corpus, mandamus, certiorari, prohibition, and quo warranto. At one level, these writs may appear technical. They belong to a lineage of common law remedies, but within the Indian constitutional context, they have been reimagined. They are no longer confined to narrow procedural functions. They have become instruments through which courts can question state action, compel accountability, and in certain cases, restructure institutional behavior. About 226, the jurisdiction under 226, I'm going to say something on a very lighter side. It is said that in England, House of Lords can do anything, but they can't change a man into a woman. Indian High Courts under 226 can do even that. So that's the range of jurisdiction of the Indian High Courts under Article 226. Of course, it has to be exercised with caution, care, and within the constitutional framework. I want to emphasize something. While the Constitution speaks of remedies in terms of approaching the Supreme Court and the High Courts, that does not and cannot absolve the other organs of the state of their own constitutional responsibilities. The burden of ensuring rights is not meant to fall on courts alone. The Constitution does not envisage a model where citizens must constantly knock the doors of the courts to secure what is already guaranteed to them. Remedies are meant to be accessible, but they are not meant to become the first and only recourse in every situation. The primary obligation to respect, protect, and fulfill rights lies with the legislature and the executive. And I would emphasize this. the primary obligation to respect, protect, and fulfill rights lies with the legislature and the executive. In fact, if we think about it carefully, constitutional remedies are in many ways a reflection of institutional failure. When a person is compelled to approach a court under Article 32 or Article 226, it often indicates that the ordinary processes of governance have not functioned as they should have. It signals that administrative accountability has broken down, or that legislative safeguards are inadequate, or that power has been exercised in a manner that is arbitrary or exclusionary. This is why constitutional governance cannot be reduced only to judicial enforcement. The executive must act with a constant awareness that its decisions are subject to constitutional scrutiny. The legislature must design laws that are responsive to the needs of the most vulnerable. Accountability must be internalized within the system rather than being externally imposed through litigation. Courts, therefore, play a critical but complementary role. They are guarantors of last resort. They intervene when other mechanisms fail. But the deeper promise of the Constitution lies in creating a culture where rights are respected in the first instance without the need of judicial intervention. If that culture is absent, then even the most robust system of remedies will remain overburdened. So while we rightly celebrate the centrality of constitutional remedies, we must also recognize their limits. They are powerful instruments, but they are not substitutes for good governance. The real test of constitutional democracy is not how frequently remedies are invoked, but how rarely they are needed. It is in this broader sense that we must understand the relationship between rights, remedies, and accountability. Remedies give life to rights, but accountability across all organs of the state is what sustains them in practice. Now, if we turn to the question of how the right to constitutional remedies is linked to social transformation, it is important to locate this within the historical context in which the Constitution was framed. Indian society at the time of independence was confronting multiple and overlapping challenges. It was not only emerging from colonial rule, it was also deeply marked, and unfortunately still is, by entrenched social divisions and hierarchical structures, particularly those rooted in caste, class, and gender. It is in this background that the idea of enforceable remedies was to empower individuals and communities to approach courts and assert those rights in the face of both state action and structural injustice. In that sense, Article 32 of the Constitution of India was conceived as a transformative tool. It enables citizens, including those historically excluded, to raise their voices within a constitutional framework. This is what we may call the first dimension of social transformation. The Constitution sought to shift the site of power. It moved from a model where authority flowed downward to one where individuals could question and challenge that authority. The act of approaching a court itself became an assertion of citizenship. It allowed people to claim rights not as a matter of grace, but as a matter of entitlement. But social transformation through remedies did not remain confined to this initial design. A second and equally important dimension emerged through judicial interpretation. Over time, constitutional courts began to expand both the content of rights and the scope of remedies. The shift became particularly visible in the late 1970s and early 1980s. The period witnessed significant social churn, including the assertion of marginalized communities, which demanded dignity, equality, and access to justice. At the same time, the judiciary began to reimagine its own role. A key moment in this transformation is the decision in Maneka Gandhi, 1978, the court fundamentally altered the understanding of personal liberty under Article 21. It held that any procedure affecting life or liberty must be just, fair, and reasonable. This interpretation broke away from a narrow formal reading of rights. It opened the door for a more substantive conception of liberty and dignity. What is important for our purpose is that this expansion of rights was closely tied to an expansion of remedies. Once rights were interpreted in a broader and more purposive manner, courts were also required to craft remedies that could give effect to those rights. The two developments went hand in hand. Similarly, emergence of public interest litigation allowed courts to relax procedural barriers. Individuals and groups could approach the court on behalf of those who were unable to do so. This was particularly significant in a society where access to legal resources is uneven. Remedies were no longer limited to those who could afford to litigation. They became, at least in principle, more accessible to marginalized communities. Citizens increasingly began to approach courts for a range of concerns that went beyond individual grievances. They invoked constitutional remedies to fill legislative gaps where the law was silent, to hold the executive accountable for arbitrary or unlawful action, and to seek recognition and enforcement of rights that flowed from and were implicit in the existing framework of fundamental rights. In this process, courts were not merely resolving disputes. They were called upon to interpret the Constitution in a manner that made rights meaningful in practice. This often led to recognition of new dimensions of rights and the development of innovative remedies, thereby reinforcing the role of constitutional adjudication as a mechanism for both accountability and social transformation. Thus, to summarize, the relationship between rights and remedies evolved in two stages. First, the Constitution empowered citizens by giving them enforceable rights and direct access to courts. Second, the judiciary expanded the meaning of those rights and developed innovative forms of remedies to address systemic injustice. Together, these developments illustrate how constitutional remedies have functioned as instruments of social transformation. A good illustration of this is the judgment in Vishakha versus State of Rajasthan, 1997. The petitioners approached the court seeking redress against sexual harassment at the workplace at a time when there was no specific legislative framework governing the issue. The court did not limit itself to addressing the immediate grievance. It framed the Vishakha guidelines, laying down binding norms to prevent and redress sexual harassment. These guidelines operated as law until Parliament enacted a legislation. This shows how remedies in certain situations have taken on a normative and regulatory character. Similarly, in several PIL matters, the courts have issued notices, called for reports, and kept matters pending through what is known as continuing mandamus. This allows the court to monitor compliances over time. The focus shifts from a one-time adjudication to sustained institutional engagement. Here I would like to refer to Professor Upendra Bakshi's article. The title is Taking Suffering Seriously, Social Action Litigation in the Supreme Court of India. Bakshi prefers the term social action litigation instead of public interest litigation. Bakshi argues that social action litigation represents a transformation of our constitutional courts from an elite, lawyer-driven institution into a forum for the oppressed. Earlier, the court functioned as an arena of legal quibbling for men with long purses, but through social action litigation, it began to emerge as a last resort for the oppressed and the bewildered. In other words, access to constitutional remedies explained beyond privileged litigations to include prisoners, bonded laborers, women in custody, and other marginalized groups. This shift was driven by what he calls judicial populism. where judges consciously reoriented the court towards the suffering of the masses. At the same time, Bakshi is not uncritical. Public interest litigation is largely judge-led, which raises questions about institutional balance. Courts sometimes promise more than they can deliver. There are difficulties in fact-finding, risks of overreach, and the danger that remedies may remain symbolic. He also notes that many cases proceed through interim orders rather than final resolutions, creating what he calls creeping jurisdiction. One of the most famous PIL petitions, which we all know, was Bandhua Mukti Morcha. How many of us are aware that the judgment rendered by the Supreme Court in that matter was never complied? And this is a fact. I mean, you may go and check it. At the same time, Bakshi also says that the court must take suffering seriously. Judges and lawyers have to confront real human suffering, not just abstract legal questions. For Bakshi, the legitimacy of constitutional law lies in its ability to respond to that suffering. Connected to this, I have another point. While we often focus on Supreme Court and public interest litigation, I believe the role of high courts has been equally, if not more, crucial in this regard. I say this from my own experience, first as a judge of Allahabad High Court at Lucknow, then as Chief Justice of Bombay High Court, and now as Chief Justice of Delhi High Court. High courts are far more accessible to citizens than the Supreme Court. For most people, they are first and often the last constitutional forum available. Their geographical reach, their proximity to local issues, and their ability to respond quickly make them central to the working of constitutional remedies. Even today, the number of PILs filed before high courts is significantly higher than those filed before the Supreme Court. However, there is also an emerging view that the intent behind PILs is being diluted through their misuse or trivialization. Courts themselves have, in recent years, cautioned against such abuse. Not every petition filed in the name of public interest necessarily advances genuine social causes, nor can they become a substitute for ordinary governance. In my experience at Lucknow, we would often see PILs being filed on matters that could and should have been resolved at the level of the executive or municipal authorities. Issues such as bad roads, maintenance of parks, or local administrative concerns were routinely brought before the High Court. These are matters that ideally ought to be addressed by the concerned authorities in the first instance without requiring any judicial intervention. There was also another trend that became visible. Certain individuals would repeatedly file PILs, sometimes every few weeks. You would find hundreds of petitions filed in the name of a single individual. This raises concerns about the misuse of PILs as a tool, whether for self-promotion, publicity, or to pursue personal grievances under the guise of public interest. On reading the newspaper every morning, whatever catches your imagination does not become subject matter of PIL. PIL was conceived as an extraordinary constitutional remedy. Its purpose was to enable access to justice to those who are most marginalized and who cannot approach courts themselves on account of any incapacity, like poverty, illiteracy, or other disadvantages of any kind. It was never intended to become a routine instrument for raising every administrative issue, nor a platform for advancing private interests. And yet, I would also say this. Courts, in many situations, try to strike a balance. They have often acted more as a facilitator or mediators rather than directly entering into the domain of governance. For instance, in several matters before the High Court in Lucknow, especially where the issue was one of routine urban governance and did not raise any substantial constitutional question or violation of fundamental rights, the court would refrain from issuing detailed directions. Instead, it would ask the concerned executive authority or the municipal authority to look into the grievances of the petitioners. The idea was not to take over the functions of the administration, but to nudge it into action. Interestingly, many petitioners themselves would insist on having some form of court direction, even if it was only a direction to the authority to consider their grievances. There was a perception that unless the issue was recorded in a judicial order, it would not receive serious attention. This reflects a deeper institutional problem. Ideally, executive authorities should respond to citizens' grievances on their own without the need for judicial prompting. The fact that courts are repeatedly required to issue such directions indicates a gap in administrative responsiveness and accountability. Courts have, in that sense, tried to do what they can within institutional limits. They have attempted to ensure that grievances are addressed while also being conscious of not overstepping into domains that properly belongs to the executive. This again brings us back to the central point. Constitutional remedies are vital, but they are not meant to replace governance. They are meant to reinforce it where it fails. I would now like to highlight that invoking constitutional remedies in many instances has also significantly shaped the discourse of our society. They have not only enforced existing rights, but have also led to recognition of new dimensions of fundamental rights that were not previously articulated. In many instances, judicial interventions have filled legislative gaps and eventually led to statutory developments. As I mentioned, a good example is Vishaka versus State of Rajasthan, where the guidelines formed by the court ultimately paved the way for the enactment of the Sexual Harassment of Women at Workplaces Prevention, Prohibition and Redressal Act. But see, just put a pause, but see how long it took to Parliament to enact the law. Vishaka was rendered in 1997. The Parliament responded in 2013. So it took 16 long years for the Parliament to respond. At the same time, some credit must also be given to the broader ecosystem within which constitutional remedies operate. Courts do not function in isolation. They respond to an awakened citizenry that demands accountability and seeks genuine intervention. It is this interaction between citizens and institutions that gives life to constitutional remedies. However, recognizing the role of citizens does not diminish the role of courts. Courts continue to occupy a crucial position. People approach them with legitimate expectations, and rightly so. The role of courts, therefore, must be carefully understood. They are not meant to routinely enter into the domain of the legislature or the executive. But at the same time, they must remain firmly anchored in constitutional principles and must exercise their jurisdiction where rights are violated. Their role is not to govern, but to ensure that governance remains within constitutional bounds. How the role of constitutional courts while exercising public interest litigation has to be understood. I may narrate a very interesting anecdote in this regard. I was delivering a lecture in the Judicial Academy at Lucknow to the Indian Forest Service probationers. They were newly recruited young officers enthusiastic to serve the nation. However, they were very skeptical about the way our constitutional courts function, especially while exercising PIL jurisdiction. A young probationer, after the conclusion of my lecture, in the question answer session, and the camera was not put off, he stood up and asked me, "Sir, if there is some lawsuit brought before a court, it should also have a culminating point. I said, yes, proceedings must end at some point of time. He then asked me, then why in TN Godavardhan proceedings have been continuing with no end to be in sight? According to him, proceedings in TN Godavardhan should also culminate. He was right, and I became numb initially. But then after a pause, I replied, continued mandamus is the answer of the day by the constitutional courts to continued failure in discharge of duties by the executive. Social transformation does not take place overnight. It is a gradual process. It unfolds over years and sometimes even decades. Constitutional remedies contribute to this process in an incremental yet effective way. But for this transformative potential to be realized, remedies must remain accessible. Constitutional remedies, if we look at them closely, are not simply legal tools. They are part of larger constitutional culture. They shape how power is questioned, how injustice is articulated, and how the relationship between the state and citizens evolves over time. In that sense, they are indeed instruments of social change, but not in a dramatic or instantaneous way. Their impact is gradual, layered, and often dependent on how different actors engage with them. When I say that constitutional remedies are part of a larger constitutional culture, I would like to highlight the role played by our constitutional courts, even in identifying the issues affecting marginalized sections of the society, which escape the attention of the legislature or the executive or even of the general populace. One such example, which instantly comes to my mind, is identifying the issues related with intersectionality, which has amply been dealt with by Honorable Supreme Court in Patan Jamal Wali in the year 2021. Supreme Court outlining the fact that experience of any kind of an assault on a woman, in case the woman belongs to scheduled caste community, just gets doubled because such a woman has a disability which results on account of interlocking of different relationship of power and play. The court further observes that when the identity of a woman intersects with her caste or class or religion or disability and sexual orientation, she may face violence and discrimination due to two or more grounds. In such a situation, it becomes imperative to use an intersectional lens to evaluate how multiple sources of oppression operate cumulatively to produce a specific experience of subordination for, say, a blind scheduled caste woman. In conclusion, I would say that constitutional remedies can transform society by shifting the location of authority. They allow individuals, including those historically excluded, to question the state. When a citizen invokes Article 32 of the Constitution of India or Article 226, it is not merely a legal act. It is an assertion that power is accountable. This carries deep democratic value. At another level, constitutional remedies contribute to social transformation by expanding the meaning of rights. Courts, through interpretation, have recognized rights not explicitly stated in the Constitution. They have read dignity into life, fairness into procedure, and equality into structures previously treated as neutral. In doing so, remedies have not only enforced rights but also deepened their meaning. An equally important aspect is the role of the citizens. Constitutional remedies function effectively only when there is an active and informed citizenry. Citizens must be willing to question, engage, and hold institutions accountable. At the same time, remedies must be invoked responsibly. Frivolous or repetitive litigation can dilute genuine claims. The credibility of constitutional remedies depends on their disciplined use. Marginalized communities must be able to assert their rights at multiple levels. This includes engaging with local governance institutions, using statutory remedies, and approaching commissions and authorities where necessary. They must invoke constitutional jurisdiction. Legal awareness in this regard is crucial. Without awareness, rights remain abstract. Without organization, grievances remain individual. Collective action supported by civil society and legal aid institutions converts rights into enforceable claims. At the same time, caution is necessary. Not every issue requires judicial intervention. If every matter reaches the court, administrative accountability may weaken. The goal is not to judicialize governance, but to strengthen institutions so that grievances are addressed at the appropriate level. The responsibility of courts, therefore, is significant. Courts must remain vigilant guardians of constitutional rights. Their role is crucial when violations affect marginalized communities who lack the capacity to assert their rights. In such cases, courts must not hesitate to intervene. Judicial restraint cannot justify inaction where fundamental rights are at stake. In discharging this role, courts must adopt a context-sensitive approach. A narrow technical reading of rights may fail to capture lived injustice. This is particularly true in cases of structural discrimination, custodial violence, or systemic exclusion. In such situations, courts must interpret rights purposively and craft remedies that address both immediate harm and underlying causes. In that sense, the true strength of constitutional remedies lies not only in their legal form, but in their ability to foster a culture of accountability, participation, and justice. That is where their transformative potential is most fully realized. I would like to part with my address today by reasserting what Dr. Ambedkar said in one of his last speeches in the Constituent Assembly. Now, from a reading of the Constituent Assembly debates, what I could find is that once the proceedings of Assembly were concluding, some doubts crept in the minds of certain members of the Assembly. How our Constitution has come up. The answer offered by Dr. Ambedkar to all such apprehensions is very crucial to note. He said, and I quote, "As much defense as could be offered to the Constitution has been offered by my friends Sir Alladi Krishnaswamy Iyer and Mr. T.T. Krishnamachari. I shall not therefore enter into the merits of the Constitution because I feel," and kindly mind these words, "because I feel, however good a Constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However bad our Constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. The working of a Constitution does not depend wholly upon the nature of the Constitution. The Constitution can provide only the organs of state, such as the legislature, the executive, the judiciary. The factors on which working of those organs of the state depend are the people and the political parties they will set up as their instruments to carry out their wishes and their politics. Who can say how the people of India and their parties will behave? Will they uphold constitutional methods of achieving their purposes, or will they prefer revolutionary methods of achieving them? If they adopt the prophet to say that it will fail, it is therefore futile to pass any judgment upon the Constitution without reference to the part which the people and their parties are likely to pay." Unquote. With these words, I conclude today and thank you for listening to this lecture today. Thank you very much.
Thank you, sir, for that detailed lecture on the role of courts, on how our courts have crafted remedies for social transformation, on the important role of the high courts, and on the discursive function that the courts can perform in creating social transformation. So, thank you, sir, again for being here. I'll now pass on the mic to my colleague Avinash for a vote of thanks.
I'd like to thank Justice Upadhyaya for that illuminating talk. The importance of a diverse judiciary, it was amazing. I credit the Chief Justice for composing the bench in that manner. We had people from South India, North India, people from different castes, different religions. And you could see how each of them had a completely varied perspective on the issue at hand. And we like to think of law as science, but it's not. The law is experience. And that's why it's so important for us to have a diverse judiciary, to have different viewpoints, so we can try and reach a better answer, a more representative answer. And that's what we're trying to do at CEDE. So if you'd like to support us, please reach out to us, and hopefully we can take that mission forward. I'd also like to thank our fellows. Our fellows so far over the last 6 years have all been students, precocious students, mature beyond their years, and who are willing to do tremendous amounts of work for very moderate pay. And they do it because they feel that they believe in the mission. Some of them have been beneficiaries of our system as well. They were CEDE candidates who were allotted internships and have continued to work with us. So I'd like to thank each and every one of them. Mimi, Dipendra, Kundan, Arsalan, Hamsadwani, and Sitamsani. They've spent countless hours. And Anurag, Disha, and I wouldn't be able to do anything without them, with our busy schedules. So we're so thankful that they put in that work. I would also like to thank our panel. We have people like Varisha, who's here, who's been there from the very beginning and has given us numerous internships for our candidates. It means a lot to us that the 100 or so lawyers that are there every year, we know that it's not perfect. Sometimes interns, they have their own issues. They can't complete the internship. But by and large, our panel has been extremely understanding and supportive. The interns come back and tell us that they've had great experiences. And our hope is that once we get those interns to put a foot in the door, they'll be able to get their own internships from there. If they've worked hard enough, the people that they've met, and that's how these networks build and grow. So thank you so much, all of you. If there are anyone else here who's on our panel, I'm sorry. But thank you for doing what you do. And if you'd like to be in panel, please reach out to us. I think that's about it. Yes, I need to thank our donors. We have one donor, actually. We operate on a shoestring budget. Ms. Saral Tangam, I'd like to thank her. If you'd like to donate to help our initiative, please reach out to us and let us know. We'll let you know how to do that. So thank you again, Justice Upadhyaya. Thank you, everyone, for coming today.